And there is the verdict against Donald Smith, convicted previously of abducting, raping, and murdering a young girl named Cherish Periwinkle. He just learned his fate. It is the death penalty. The jury in Florida that convicted him decided his punishment should be death. The jury found all 6 aggravating factors against this defendant, found only 2 mitigating factors, and said the aggravators are outweighing the mitigators. So, bottom line, a death sentence, and we saw the defendant nodding when that sentence was read. The editor-in-chief here at Law&Crime is Rachel Stockman. She joins me today. I don't think this was much of a surprise. The finding of the 2 mitigators was a bit of a surprise.
Yeah, we have to go back and kind of look at Florida law, because the 2 mitigators they found was A, that he was over a certain age, which just might be a statutory thing that they had to find.
Over the age,
right.
The light turns green, they find it.
And then the other mitigating factor was that he had a relationship with his son, which he did, and his son, Donald Smith Jr., actually came and testified during the sentencing hearing yesterday via Skype. So overall, I have to say I was not surprised by this verdict. I figured this was going to happen. The list of mitigating factors was, quite frankly, somewhat pathetic by the defense in my mind, what they tried to put forth as mitigating
well,
factors.
they get to throw whatever they want.
Right, yeah.
I mean, the statute lists what the aggravators are, but the defendant can throw anything in. I mean, if he stepped on chewing gum on the sidewalk, apparently they can throw that in as a potential mitigator. And look, all it takes is one juror to find that factor, and then they can roll with it. But here, the big headline, I think, of the mitigators was that the jury saw through all of the mental health, the family violence, the family instability, whether or not this guy was suffering from some mental health issue or brain disorder. They found none of that. So that the jury just said, we don't agree that that's an excuse.
I almost think they looked at this list flat out and just were like, we're not even gonna consider some of this. We think it's such BS, honestly. However, they did deliberate for 2 hours and 15 minutes or so?
2 hours 10, somewhere in there.
So clearly something was hanging them up. Like, they didn't go in there like they did for the guilt phase and just say within a couple of minutes, 12 minutes, that this guy was guilty. So, there was some debate, and perhaps it was regarding that one mitigating factor, which was the relationship with his son. And that was the only part, honestly, as I watched the entire death penalty phase that was the only thing that did get me a little bit, was the son when he testified, and kind of thinking, okay, here is a guy that didn't bring this upon him, and he's going to now have to lose his father over it. Not that I feel bad, but so definitely interesting, definitely not a surprise.
Yeah, David Pietro is one of our guests here at the Law&Crime Network. He's an attorney in Florida. He joins us now. David, your reaction to this death sentence just moments ago being handed down?
Not surprised at all. This is a case where it was if you could call it an ideal death penalty scenario. It really was a long-time perpetrator, a helpless, a young child as a victim, and from a person who's not, there's really no redeeming qualities to Pietro. So I think I said early on in this case, on a previous segment, when the case started, this was going to be one that it was ideal for the death penalty, and I think all the evidence supported that. And the area in the state of Florida is a little more conservative in Jacksonville, so overall not surprised on the actual verdict and death sentence recommendation.
Yeah, the victim here, Cherish Periwinkle, 8 years old when this defendant was caught on surveillance footage leading her out of a Walmart store where he basically had lured the family. He was probably quick enough to pick up that this family was struggling financially, and that was the guise, that was the ruse. He said, look, I'll help buy clothes, and the mother believed it, even though she did have a couple of bells going off in her head that something wasn't right. She thought, who would try to harm my daughter in a store where there are many people present and there are cameras everywhere, but yet it still happened. So does this bring justice?
I think so. I mean, listening to the 911 call that the mom had originally, or what they had gave when her daughter was missing, I mean, it's probably one of the saddest things you'll hear. I think the death penalty has gone through a lot of phases in our society where it was probably overutilized. And I think, though, even our Supreme Court, Florida and the United States Supreme Court still preserved it. And I think these are the cases that I think the courts will support the death penalty. The Ted Bundys of the world, the sociopathic killers that will kill whether they're in jail, prison, or on the street. This is the category of defendants and criminals that I think the death penalty is going to be preserved and exist. It's not going to be, I think, for drug dealers who kill each other and other violent crimes and things like that. I think it's going to be left for the sociopathic murders of very innocent people like we've seen in this case.
You know, and that's exactly what we had here. I know, Rachel, we've talked about this a little bit. You've got a guy who preys on arguably one of the weakest members of society out there, and the reaction to it is just disgust. It's absolute disgust.
Well, one of the things that was kind of interesting that happened during the death penalty phase was that the defense brought a mitigation specialist up to the stand, and some doctors and a prison expert. And specifically, they were trying to get the prison expert to testify in front of the jurors what kind of life Donald Smith would have in prison after he went to prison for this, saying he's going to be considered the scum of society, he's going to be treated horribly in prison. I found that very interesting that maybe David can weigh in on this, that they were actually trying to use that as a mitigating factor for what could happen in the future to Donald Smith if he got prison without the possibility of parole. The judge didn't allow them to go down that route. Have you ever heard that happening before, David?
That's a first, even for me. And I don't think this jury, that probably worked in the favor of the prosecution, right? I think that was a counterintuitive move. So I don't see whether he was going in. He's actually going to be more protected in Stark, which is the prison he's more likely to go to in North Florida, where they house the death penalty convicted prisoners, because they segregate them and they keep him isolated. So he's probably safer under a death penalty scenario than he would be in general population.
Yeah, I mean, look, we know of prisoners who are convicted of crimes against children, sexual crimes against children, that they are the lowest of the low in prison. Other inmates loathe them. You know, there's this pecking order in prison, and they're at the absolute bottom of it. So it was sort of an interesting tactic by the defense, but
it didn't work.
It didn't work, and it may have backfired, but they tried it. You know, I guess they figured that they really don't have much to lose. And,
well, I think that was obviously their strategy. I mean, talk about throwing everything in the kitchen sink out there in terms of mitigating factors. I was actually surprised and didn't realize the list as the judge was reading through all those mitigating factors. I mean, it was just one thing after another after another. I mean,
I stopped keeping count.
Yeah.
You know, but they can throw in, and David, I think you know this better than I do, they can throw in pretty much anything they want. You know, the state is held to a list of aggravating factors, but the defense can make almost anything a mitigator.
Right, because when you look at under the statute where it has the mitigators, they have that last one that says any and all factors that the jury reasonably can consider, or whatever the language is thereabouts. So that gives the defense, and that's the way the law should be. It should allow the defense to do, the state should have a tighter scope, and the defense should have a wider arena to put out their mitigators, so that fairness leans towards the defendant. And if he's then convicted and recommended death, even with all being able to present a very loosey-goosey amount of mitigators, then he can't complain later on in appeal, I didn't have a chance to present X, Y, and Z evidence.
David, you mentioned something before. I wanted to ask a follow-up about it. You said that this conviction occurred in a more conservative part of the state. Do you think that the outcome could have been different somewhere else?
Well, I'm in the most liberal part of the state, and I think that more likely than not, it would have been the same result, because under Florida law, you still have to, they segregate the jurors and they individually interview them. The first question they ask is, when they're doing the potential panels, can you follow the law and can you deliver a death verdict? So if you cannot deliver a death verdict for whatever reason, religious, moral, or you just can't do it, you're automatically stricken. So you are getting a jury pool not only that is conservative, because they usually people that believe in the death penalty tend to be more conservative. Then also you're in a conservative area in the state. So that's why, to me, it was a no-brainer. It seemed like a slam dunk potential death penalty case. Whereas we've seen a couple in Florida so far that since the Supreme Court changed it, they haven't been able to get to 12 because of whatever, there's other extenuating circumstances or mitigating circumstances under the scenario.
So one more thought here. When this thing was grinding through the process, the defense tactic seemed to be to blame the press that this case received so much attention that it was impossible to get him a fair jury anywhere in the state. David, if I'm reading you properly, I think that you agree that that was a hogwash claim.
Yeah, until your show started following it. I mean, I'm pretty far away from that area in South Florida. That's North Florida. I wasn't even really familiar with the case. So to say that statewide they couldn't receive a fair jury, I think is doubtful. I think the Nicholas Cruz case that's in my county, now that's a different scenario. That's a better argument for the wide reach that case has spun nationwide. I don't think this case has that far of an impact.
Rachel, I would agree. Wondering what you think.
Well, I did want to, as we kind of talk about this, like I said, I don't think it was much of a surprise. One thing was surprising to me that did happen today, and that was the fact during the closings, when the defense attorney was giving her closing argument at the end of the death penalty phase, we actually saw Donald Smith, for the very first time, get emotional about what was happening. Throughout this entire trial, he's been kind of blasé, kind of staring off. He started crying. And why did he start crying? Because it was the defense attorney was talking about how messed up his life, what trouble he had in his life. So I think that could have also played in. Imagine that is the very last thing the jurors hear and see before they go deliberating, and here they see this man finally getting emotional and has nothing to do
with the victim.
With the victim.
It has to do with his own circumstances. So he sees himself as a victim. And look, it doesn't look like life dealt this guy the best cards that it could have. But, the jury's going to look and say, why didn't he make lemonade out of the lemons? Is this really the outlet for everything bad that happened to him to inflict something bad on someone else? The jury's not going to be sympathetic to that at all.
They're not going to buy that at all. And his little cry fest there at the end, I think we do have video of it somewhere, I don't think was very, very convincing at all. If anything, it just made us all scream as we were watching this. Oh, okay, now Donald Smith is finally getting upset about something. What about when the medical examiner was going through the brutality that he caused on this little girl?
He just sat there as if
pictures.
He just sat there as if he recognized it. Like, oh yeah, I did that.
What about when the mom was crying on the stand about losing her daughter? Why wasn't he crying then? Sorry, this case gets me a little emotional myself.
And not only that, usually he's just sitting there like playing with his mustache. He's not really reacting too much. And then at one point, remember, he got up and posed for the photographer on his way out of the courtroom. That was another bizarre thing, like wanting to take ownership of this in some way. Presumably,
like I said,
the jury probably didn't see it, but everybody else did.
Like I said, this is a sick man. This is a man who went to trial because he enjoyed the limelight. Why the heck else did he go to trial on?
Well, I think he went to trial because he probably wasn't offered anything in a plea.
He said in a previous comments to the media that he wanted to die. He was happy with the death penalty. So if that's true,
well, and he nodded when it was ultimately
so if that's true, why did he go through with this? Ordinarily, I'd say to you, Aaron, that's absolutely right, that he did this because he wanted to avoid the death penalty. In this case, I am convinced he went through with this trial merely because he's a sick man that wanted the publicity out of it and wanted to sit there, and maybe he enjoyed it, which is even sicker.
I mean, it allowed him to relive the crime somehow. You may be right. You may be right. So we do have Another trial that's going on live, we want to dip back into that. I think we're going to go back there very soon. This is another case we're covering here at the Law and Crime Network, the Burge case out of northeastern Wisconsin. They might be in a break in that case, though. It looks like the judge might be off the bench. So we've been covering that case. Maybe, Rachel, I can pick your brain about that a little bit because we both lived up there. We both covered the judge, John Zukowski, who was the prosecutor when we worked there. And
yeah,
now
I kept
he's the
staring at
judge.
him. I knew I knew him from somewhere, but I couldn't piece it together.
Your 10 years have gone by. My hair is grayer. You look the same, and he has another 10 years or so. It looks like that trial is actually over for the day. So we are going to talk a little bit more about both cases. We've got some evidence on the stand this afternoon in the Burge case, basically indicating that there was blood, there were hairpins and wire found right near the house that the victim shared with the boyfriend. Now, keep in mind, this is the boyfriend that the defendant's trying to point the finger at and saying he's the real killer. So, this is just a bizarre situation. But we heard the boyfriend testify, and it seems to me that, he doesn't sound like the most stand-up guy in the world, but does that necessarily mean he's a killer?
Yeah, I didn't find anything in his testimony. I'll be honest, I missed a little bit of it this morning. But from what I saw, which was almost all of it, I didn't see any so-called smoking gun that the defense scored some major points, especially during cross-examination with this guy.
I thought the cross-examination is relatively weak, but we'll talk about that in a second. Let's jump back and review the verdict again that just came in moments ago. The jury deliberated for 2 hours and 10 minutes in the penalty phase of that death penalty trial in Florida. The verdict was read just moments ago. Let's review it.
All right, I've reviewed the form to make sure it was filled out correctly. I'll read the verdict. State of Florida versus Donald James Smith, verdict as to sentence. We, the jury, find as follows as to the defendant, Donald James Smith, in this case. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Donald James Smith, in this case. Donald James Smith was previously convicted of a felony involving the use or threat of violence to another person. The first-degree murder was committed while Donald James Smith was engaged in the commission of a kidnapping and a sexual battery. The first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. The first-degree murder was especially heinous, atrocious, or cruel. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cherish Periwinkle was a person less than 12 years of age. Reviewing the aggravating factors that we unanimously found to be proven beyond a reasonable doubt in Section A above, we, the jury, also unanimously find that the aggravating factors are sufficient to warrant a possible sentence of death, and they have marked yes. As to mitigators, we, the jury, find that the following statutory mitigating circumstances have been established by a greater weight of the evidence as to the defendant, Donald James Smith, in this case. I'll read the mitigator and then the answer. The first-degree murder was committed while Donald James Smith was under the influence of extreme mental or emotional disturbance. No. The capacity of Donald James Smith to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. No. Donald James Smith's age at the time of the crime, yes, by a vote of 12 to nothing. Donald James Smith's biological father left before he was born. As a result, he never had a relationship with him. No. Donald James Smith's parents were forced to divorce by his maternal grandparents, who openly disapproved of his biological father. No. Donald James Smith's mother was 17 years old when she gave birth to him. No. Donald James Smith was born premature with a low birth weight. No. Donald James Smith's mother wanted to give him up for adoption. No. Mental illness runs in Donald James Smith's mother's side of the family and in his biological father's family. No. Addiction runs in Donald James Smith's mother's side of the family and in his biological father's family. No. Emotional instability leading to physical violence is present on Donald James Smith's father's side of the family. No. Donald James Smith's paternal uncle shot his grandfather to death. No. Donald James Smith's mother spent very little time with him as a baby, instead focusing all of her attention on finding a man who could provide her with the lifestyle her parents felt she deserved. No. Donald James Smith moved out of his grandparents' home when his mother married Clifton Smith, the man who formally adopted him, which was extremely traumatic. No. Cliff was verbally and emotionally abusive to Donald James Smith. He also locked Donald James Smith outside as punishment. No. Cliff was physically abusive to Donald James Smith. No. Donald James Smith was traumatized by his stepfather's treatment. He became clingy, stopped eating, and wet the bed long past the age of typical potty training. No. Cliff was paranoid and obsessed with violence. Donald James Smith was terrified of what he witnessed. No. Cliff's job in the insurance business forced them to move regularly. As a result, Donald James Smith was repeatedly uprooted from his home, adding to the instability of his living environment. No. Because of the frequent moves, Donald James Smith was frequently bullied. This caused him to feel alienated, detached, despondent, and angry. Donald James Smith resorted to paying other kids to play with their toys. No. Donald James Smith was sexually molested at the age of 8 by 2 neighborhood teenagers. No. The teenagers coerced Donald James Smith into watching them violently sexually molest several girls. He found the experience confusing and frightening. No. Donald James Smith did not reveal the sexual abuse to his mother. No. Donald James Smith's mother suspected that her sister's husband, Bob, molested her son. However, she did not confront them. No. Donald James Smith never received treatment for the sexual abuse he endured. No. Cliff was sexually inappropriate with Donald James Smith. He touched Donald James Smith on his buttocks. He called Donald James Smith sexually explicit names. No. When his mother divorced Cliff after 7 years of marriage, this was yet another change that brought instability into Donald James Smith's life. No. Donald James Smith's second stepfather, Dr. Marlon Moore, was a cold, self-centered, and aloof man who insisted that his wife and stepson call him Dr. Moore. No. Dr. Moore was verbally and physically abusive to Donald James Smith. He made it known that he didn't have time for children. No. As a teenager, Donald James Smith began self-medicating with pills from Dr. Moore's home office. He was never confronted with the drug use. No. Donald James Smith's drug abuse escalated to regularly using marijuana, LSD, PCP, MDA, mescaline, peyote, quaaludes, and cocaine? No. Donald James Smith dropped out of school in the 10th grade. Although Donald James Smith was intelligent, he had lost all motivation based on drug use, depression, and anger. No. As a teenager, Donald James Smith began to get arrested. No. At the age of 15, Donald James Smith began engaging in voyeurism. No. Donald James Smith was raped while incarcerated. No. When Donald James Smith was released from jail, his drug abuse spiraled into full-blown crack addiction. No. On crack, Donald James Smith's inability to control his impulses was intensified to the point that he felt like another person. On the streets, Donald James Smith became notorious for his behavior while high. He was paranoid, manic, unstable, and impulsive. No. Donald James Smith's mother enabled his drug addiction. She drove him to pay off his drug debts and, if he was unable to make the trip, paid them off herself. She continued this for decades. No. At the age of 20, Donald James Smith attempted suicide for the first time by driving into an oak tree on Orange Picker Road. He flipped his car but survived the accident. Donald James Smith did not receive treatment for his injuries. No. Donald James Smith experienced a dissociative episode due to drug use where he lost time. No. Donald James Smith made his second suicide attempt in the Duval County Jail. No. In 1977, Donald James Smith was designated as a mentally disordered sex offender and committed to the North Florida Evaluation and Treatment Center. No. Throughout his adult life, Donald James Smith spent hundreds of dollars per day on crack. During the year of 2002, he spent more than $90,000 in a 4-month period. He went on binges that lasted for weeks. During these episodes, Donald James Smith did not eat or sleep. No. Donald James Smith fathered a son, Donald James Smith Jr., born June 2, 1992. He married his son's mother, Francine Brown, but the relationship was short-lived. No. Donald James Smith was far from a perfect father. However, he has tried to parent his son to the best of his ability. No. Donald James Smith Jr. has developed a close relationship with his father since he has been incarcerated. Yes, by a vote of 7 yes to 5 no. Donald James Smith has been repeatedly diagnosed as having antisocial personality disorder, polysubstance dependence, pedophilia, and cocaine dependence. No. In 1999, Donald James Smith was designated as a sexually violent predator and subsequently committed to the Martin Treatment Center through the Jimmy Rice Civil Commitment Act. While detained at MTC, Donald James Smith did not complete the treatment plan developed for him. No. While at the Martin Treatment Center, Donald James Smith engaged in a sexual relationship with another patient who was known for being HIV positive. This was regarded as Donald James Smith's third suicide attempt. No. In spite of the fact that Donald James Smith did not participate in counseling, he was released from the Martin Treatment Center based on a decision made by members of the State Attorney's Office in Duval County. No. Once released from the Martin Treatment Center, he was required to receive a psychosexual evaluation and treatment. Dr. James Vallely completed the evaluation and concluded that Donald James Smith was highly likely to reoffend. No. Donald James Smith was arrested for dealing in stolen property and burglary and was eligible to receive 30 years in prison as an habitual offender. However, members of the State Attorney's Office in Duval County permitted him to plead to a sentence of 4 years in prison. Donald James Smith was not placed on any form of supervision upon his release from prison. No. In 2006, a state psychological assessment determined that Donald James Smith did not meet the criteria for civil commitment in the Jimmy Rice Civil Commitment Center, although he had never received any meaningful rehabilitation. No. In 2011, Donald James Smith Baker acted himself. He reported homicidal thoughts, auditory and visual hallucinations. He also admitted a history of using cocaine and Lortab. He was diagnosed as having a potential for homicide, suicide, and violence. The center recommended one-on-one counseling and let him stay 3 or 4 days. They never followed up with therapy. No. In 2009, Donald James Smith was arrested for attempting to lure a 9-year-old girl while posing as a Department of Children and Families worker. If found guilty, he could have been sentenced to 10 years in the Department of Corrections, but members of the State Attorney's Office in Duval County agreed to a plea agreement allowing a county jail sentence, which bypassed further screening into the Jimmy Rice Civil Commitment Center. No. On June 1, 2013, Donald James Smith was released from Duval County Jail. He was not placed on any kind of supervision by the state of Florida. No. 3 weeks before the murder of Cherish Periwinkle, Donald James Smith went to Shands Hospital and then was Baker acted. He stated that he was having violent thoughts and wanted to get into a residential program. The center gave him a new brochure and told him to study and practice. They allowed him to stay approximately 24 hours. No. Neuropsychological testing has indicated that Donald James Smith's brain functioning is abnormal. He has deficits in executive functioning and poor impulse control. No. Donald James Smith's neuropsychological disorders are exacerbated by substance abuse and addiction. No. Medical testing, specifically PET, MRI, and DTI scans, have revealed that Donald James Smith's brain functioning is abnormal. No. Donald James Smith's brain abnormalities are consistent with someone who has suffered brain damage. No. Donald James Smith has suffered from significant mental illness for most of his life. No. Donald James Smith's mental illness is not something he has chosen. No. Donald James Smith did not choose his family. No. Donald James Smith did not choose the way his family treated him. No. Donald James Smith did not choose to be sexually molested. No. Donald James Smith's childhood experiences shaped the person he became as an adult. No. At the time of the offenses, Donald James Smith was 56 years old. He is now 61 years old. No. Donald James Smith has been diagnosed with chronic obstructive pulmonary disease, COPD, heart disease, hepatitis B, and hepatitis C. No. Donald James Smith has been a strong support system for his mother, who is receiving treatment for breast cancer. No. Donald James Smith has not been a threat to correctional officers or other inmates in the Duval County Jail and the Department of Corrections. No. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A above outweigh the mitigating circumstances established in Section C above. Yes. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A above, that the aggravating factors are sufficient to warrant a sentence of death in Section B above, and that the aggravating factors outweigh the mitigating circumstances in Section D above, we, the jury, unanimously find that the defendant, Donald James Smith, should be sentenced to death. Yes. And so say we all, this 22nd day of February, 2018, and signed and dated by the foreperson.
Ultimately, a death verdict there for Donald Smith. He was convicted previously after 12 minutes of deliberation by a jury of kidnapping, raping, and murdering an 8-year-old child named Cherish Periwinkle. Now he will face the death penalty, the jury finding only 2 mitigating factors. One, that his son has a close relationship with him, and 2, that he was an older man when he committed the crime. Those were the only 2 mitigators. But the jury found 6 aggravators. All 6 that prosecutors put in front of this jury were agreed upon by that jury. And the jury found that in the balancing test, in the end, right before the decision as to the penalty, that the aggravators outweighed the mitigators. Therefore, a death sentence was proper. That was the jury's finding in Florida. The mother of the victim was in court when that verdict was read, that sentence was read. Here was how she reacted. She was walking out of the courtroom, got a hug from presumably a friend or a relative there, and also hugged a member of the uniformed police or sheriff's department who just happened to be standing nearby. A long, arduous, painful process for that mother. One of the most memorable parts, one of the most emotional parts of that trial was the mother talking about placing a frantic 911 call in a Walmart store, realizing that her daughter had been taken away, and later surveillance footage proving that that's exactly what happened. So this verdict perhaps giving some finality to the family. We are waiting for a court to resume in the George Burge trial in Wisconsin. We had heard earlier that that might be wrapping up early, but apparently the judge is going to try to squeeze one more witness in. They've been on a lengthy break while they perhaps wait for that witness to arrive at the courtroom, because the judge said earlier that things were moving a lot more swiftly than he thought they would today. So there have been a couple of pauses in that case as new witnesses have been waited for, one could say, in the courtroom. Usually witnesses are given times to appear, and if things move along very quickly, sometimes the next witness isn't even in the facility yet, and that may be what happened this afternoon. The judge also said that there was a bit of an unexpected legal wrangling maneuver that they have to deal with at some point today, so we're curious to see what that's going to involve. We're not allowed to transmit during the motions hearings in this case when the jury's not present. That's a bit of a departure from what we normally see in other cases, so we can report on them, but we can't bring them to you. I'm curious to see what that's going to be all about. But one of the critical parts in that case has been this accusation by the defendant that it wasn't him who committed the murder of a young mother in the Green Bay, Wisconsin area about 2 years ago, but rather that mother's boyfriend and the mother of the baby that they had together not long before. In Wisconsin, if a defendant is going to point the finger at somebody else, the burden is pretty high in that state. And those of you who watched Making a Murderer probably know the rule by heart now because it's come up in the appeals process as Stephen Avery's attorney tries to fight to get out of prison on his own charge. Now, those standards also apply in this case. So the defendant has to prove means, motive, and opportunity against the boyfriend that the defendant's pointing the finger at. Police ruled the boyfriend out as a suspect, even though they initially arrested him and examined him, but they later let him off the hook. So the defendant has to prove means, motive, and opportunity to point the finger at the boyfriend. That happened during cross-examination. I was hoping to play some of that for you, but it looks like the judge is taking the bench in the Burge trial in Wisconsin, and we might have sound any minute here. Again, we heard that this was going to be delayed, but it is starting back up again. The judge is on the bench, and he appears to be looking over at the clerk. Let's try to show both at once here, because this should be starting up any moment now. Again, the defendant, who was a newcomer to the Green Bay area, is accused of basically murdering a young mother who he claims to have met at a bar right before that young mother disappeared. He claims, this meaning the defendant, that he met her at a bar, she went home with him, agreed to have sex with him, and that explains his DNA on her body. But he claims that he was forced to go along with the disposal of the body by the boyfriend, the real killer, and that the boyfriend threatened him with a gun, that he had to go along with it. So finger pointing back and forth between the defendant and the boyfriend. The boyfriend on the witness stand says he didn't have a sawed-off gun or any gun that he could conceal to sort of use as a threat against the defendant. So the defendant's story would presumably be falling apart, even though the defense was able to take a number of jabs at the boyfriend on cross-examination especially, although I think the prosecutor deflected a lot of it on direct examination, involving whether or not this boyfriend was a good guy. Look, he was out at a bar with the victim right before she disappeared, and a lot of people could say that he ditched her, that he basically left her, the woman with whom he had just had a newborn baby, to hang out with some other people. And there were a lot of heated text messages back and forth between the victim and the boyfriend. Some of those text messages were examined. I want to play some of that graphic testimony for you now.
The last area of questioning was that Nikki had left the watering hole with a group of your friends. And do you know about how long after Nikki left the watering hole did you or Greg start to receive some information that you should come down to the sardine can?
I don't exactly recall if she had said something about the sardine can in the short phone conversation we had, but probably received some text from her, I don't know, I'm guessing 15, 20 minutes after that point.
In your short phone conversation that you had with Nikki while you were still at the watering hole, was she at the sardine can at that time?
No, I remember her saying, I think they were in the parking lot in the car about to leave.
Was Nikki upset with you at that point in time?
No, she didn't seem to be.
Shortly thereafter, you indicated that you received some text messages?
Yes.
At some point, did Nikki send you a series of angry text messages?
Yes, she did.
Do you recall the content of those angry text messages?
I don't specifically recall exactly what they were. I know that, or I don't know, I don't really want to guess, but they're like, what girl am I talking to, or something on the lines of that, and some other comments that I didn't know where they were coming from. And
Is it fair to say that some of those text messages were really rather upset or derogatory?
yes, they were.
This may not be pleasant, but if I read them to you, can you tell me whether or not that was a text message you believe she sent?
Yes.
Do you believe that at around 11:12 p.m. she sent you a text asking you, quote, "So what bitch you with"?
Yeah, that rings a bell, yes.
You recall her sending a text message that said, "Fuck you, abusive asshole"?
Yes.
Do you recall her sending a message that said, quote, "Wow, what slut are you with? Because none of your friends know"?
Yes, I do.
And another one that said, "I am not surprised. How many times have your dick been off for some whore"?
Yes, I do.
Do you recall responding to Nikki's text messages?
I believe I received those all like as a bunch grouped together that I had missed, that I had not looked at the phone in a few minutes or however long it was, and saw them all, and I responded back something kind of nicely, just trying to diffuse and maybe calm her down, because she seemed upset from the content of her text.
Was your response to her an angry response?
No, it wasn't. I wasn't upset.
How did it make you feel when you heard those text messages?
I was kind of puzzled. I didn't know what she was thinking, or I didn't know what was going on, you know.
Did Nikki continue to send derogatory text messages to you?
Yeah, I believe she sent some more after that.
Do you recall getting a text message that said, quote, "Sure, you still love whores"?
Yeah, something like that, yep.
And do you recall what your response was to that?
I think I did like an LOL or something like that back to her, and like, are you joking? Are you kidding? What's going on here? I didn't get it.
Do you respond, and do you recall her sending you a text saying, quote, "Yup, I learn lots"?
Yep.
And, quote, "Why else you so fucking retarded"?
Yeah.
Do you recall responding to that text message?
I don't know what text I specifically responded to at what point, but I did respond back here and there, when I did look at my phone and noticed that she was still, texting me, and I don't know at what point I tried calling her too, and
Do you recall if any of your responses to her text messages were angry responses?
no,
Do you recall using a vulgar language with her in response?
no.
And why did you not respond in a vulgar or upset way?
Well, I wasn't upset, and I think I just kind of thought she was upset for an unknown reason, and that there wasn't really a reason for it.
And in fact, is it fair to say your responses were, you mentioned LOL or LOL, stop it, Nikki,
Yep.
and then just saying that you would be there soon or find her?
Yep, that I'd meet her at the sardine can or whatever. I'll be there soon.
Do you recall if the derogatory text messages then continued even after that?
I believe they did, yes.
And at any point in response to those messages, did you get upset with Nikki?
No, I didn't.
In fact, at one point she did send a text message that said, "You hurt me all the time."
Yes, she did.
So those are some of the nasty text messages that went back and forth between the victim and her boyfriend, the father of her child, and the initial man police looked at in this murder case out of Green Bay, Wisconsin, before ultimately deciding that another guy, the defendant, was the one that they wanted to charge. David Pietro is an attorney, still on the line with us now. David, this is a real finger-pointing situation, and as I was saying before, it's pretty tough for defendants in Wisconsin to point the finger at someone else as an alternate suspect, because it's easier for the state to point the finger at a defendant than it is for the defendant to raise an alternate suspect. All the state has to prove in Wisconsin basically is intent, okay? The state doesn't have to prove premeditation. They just have to prove that somewhere in the facts, the defendant wanted the victim to die. And if the victim points the finger at somebody else under Wisconsin law, this is a Supreme Court case, the Denny case, the defendant has to prove means, motive, and opportunity, which in this case, in theory, the defense can try to wrangle that together based on the facts. And that's why we have a named alternate suspect here. But it takes a lot of wrangling, and the jury's probably going to be sitting back there, at least I presume, trying to figure out, okay, is the defendant the guy or is the boyfriend the guy?
Yeah, it seems so, but I think the boyfriend actually handled the questions pretty well. And ironically, even though he may have been not the best boyfriend in the world, he actually handled the text messages pretty well. I mean, I think he could have come off a lot worse with anger and aggression, and it wasn't quite there. So I think their broad brush of painting him as sort of a sleazeball maybe didn't have that full effect for purposes of a homicide. It makes him show that maybe he is not the most loyal guy in the world, but not the one that would develop this kind of intent. And it seems that really the prosecution, it's amazing what technology's done in this case, unlike other cases, because the boyfriend could have easily been the one on trial based upon the facts without technology and the ability to track the defendant. So this case is fascinating in a lot of regards, but that line of questioning, although I don't blame the defense for putting on there, it's definitely worth putting on there. I don't know if it had the full effect that they were looking for.
Yeah, look, I thought the cross-examination of that boyfriend was pretty lousy. I get what they were trying to go at, but I think they needed to be tighter with it. And I think that they needed to be a little bit more assertive with it, David. Will the jury see through the smoke and mirrors? Let's hope. But the Burge trial is back in session after a lengthy break and some legal wrangling. Let's go back in. Another witness about to take the stand.